It's really excited to see everybody here, and I'm excited to imagine the world with psychedelics, what that would look like. It's a really exciting time now. And just a brief intro about me, my name is Serena, and I co-founded Radical Law, a boutique corporate law firm that focuses on social impact work, emerging companies, and startups. And one of the ways that I wanted to create impact was through the world of psychedelics. And as you can see, like this from today's talk, what you'll learn is the variety of the history, the legal landscape, the IP issues that arises, and also what's happening in the clinical research realm. I came into this space basically through my own personal journey, but also because I wanted to use my legal skills in a way that would be helpful and impactful to the world. I will let my colleague introduce herself, Anusha Kakani.
Hi, everyone. My name is Anusha Kakani. With Serena, I co founded Radical Law a couple of years ago. We both are roommates from Harvard Law School. We would never imagine that we would then one day go on to found our own law firm, but here we are. We also did not color coordinate beforehand. So, I guess it was meant to be. But Radical Law, we founded Radical Law with a simple mission to empower change makers. We wanted to be the practitioners that are bringing new ideas, new thoughts into the forefront and empower these change makers with the legal expertise that they need to achieve their mission, their vision. And it doesn't get more groundbreaking than psychedelics. And we are super excited to dive into the landscape, the opportunities, the challenges, and all of the above. So
one more thing before we introduce our first speaker, we just want to give a shout out to all the sponsors: Aquilius Ventures, Aquilius, and Start Out San Diego.
And a big thank you to Aquilius. They've been friends of Radical Law for a while, our strong supporters as well, and we couldn't be happier to be with all of you here today. So with that, we're really excited to get started with our keynote speaker, Karen Luong. And Karen is going to dive into understanding psychedelics, the legality, the regulation, the cultural shifts. Karen is a founding member and co-leader of the Psychedelics and Emerging Therapies practice group at Husch Blackwell. With over 16 years of experience in product liability litigation, focusing on toxic products, Karen has a unique perspective in the emerging area of psychedelic therapeutics. She keeps current on the academic and commercial research and drug discovery efforts in this rapidly changing field, such as the development of medicines for PTSD and treatment-resistant depression. Karen assists psychedelics clients in navigating and complying with complex regulatory issues and protecting and commercializing intellectual property. She has a particular focus on helping clients forecast and take steps to protect against potential claims for product liability. Karen, we're really excited to have you.
Great to be here today. Thank you so much for the introduction. And my name's Karen, based in LA, live in Orange County. I realized that bio was a little old because now it's almost like 18 years that I've been a product liability litigator, which means that if you've been sued for your allegedly dangerous product allegedly causing injuries, I'm the person who is in court. I'm gathering the evidence to defend companies against these claims, and I'm trying to knock out the other side's evidence and eventually presenting it to a jury to convince them that getting the DA Schedule 1 license and a lot of the sort of more nitty gritty, but this is the first time I've done this. I really want to start with sort of an FAQ because I've been getting more and more questions lately from prospective clients. This idea, this great idea, is it legal? Unfortunately, most of the time I have to say no, it's not. But I want to do is talk about what's legal, what's not, and really enable, hopefully, you'd be able to just have a conversation at dinner or somewhere with people when you're talking about psychedelic therapy and be able to understand maybe a little bit of why and why things are legal by them. So I think the bedrock principle of this is right now, the only legal use of a Schedule 1 controlled substance, so that is all the substances that we're going to talk about other than ketamine, which is Schedule 2, right? The only legal use of a Schedule 1 controlled substance generally is to enable the research or drug development under a valid DA license. And so you have obviously manufacturers, you have importers, things like that, but the ultimate goal is really to link back to it for research and drug development, and there needs to be a DEA license. With that, I get this question a lot. Is microdosing legal? Or what if I have this awesome business idea and I want to research the, developing a hand cream or a tincture that only has like just the tiniest bit of psilocybin. It's not a lot, like the teeny tiny bit, and it's not even psychoactive. It's so small that nobody is ever going to be able to tell that there's psilocybin in this. Okay, so the answer is no, microdosing is not legal. I get asked this question so much that I actually called the DEA in Los Angeles, and a funny story about that is I forgot that when I rattled off my phone number for them to call me back, because I guess if you call them, they don't have a receptionist, and they just call me back. Leave a message. I'm so used to leaving my personal cell phone number that I left my personal cell phone number there, and I completely forgot about it. A week later, I get this call from an unknown number, and they're like, "Hello, this is Agent whoever from the DEA," and I freak out because I haven't done anything wrong. I'm just like, why is somebody calling me in the middle of the day from the DEA? And she's like, "I'm returning your call from last week." Oh, okay. So we talk about this, and I tell them, "Hey, I get some questions from companies that are developing the tiniest amount of psilocybin. What is your view on this?" What I was really trying to get from them is, are you going to enforce against this? Because we both know that it's not legal. But they just laughed at me and they said yes. Unequivocally, it is not legal, and they wouldn't tell me whether or not they're going to, or whether or not the priority of the DEA to enforce. Obviously, they wouldn't tell me that. But there you have it from the horse's mouth. Microdosing is not legal. Neither is developing your business with microdoses. You can really so thinking back about it, it's because if you're developing a hand cream that has the tiniest bit of psilocybin in it, you're going to get that from somewhere. Somebody out there is manufacturing it or importing it, and it's not going to initially start in a dose that is a microdose. And that's why it's still a Schedule 1 controlled substance, still not legal. I get this question a lot. I've heard that psychedelics have been decriminalized in, a certain state or a certain city. They've been legalized in Oregon and Colorado. Does that make it legal for me to operate a business or develop a business in that state or city? So let's talk a little bit about the difference between decriminalization and legalization. Decriminalization happens when a municipality or a state or whatever has decided that they are not going to expend their resources to prosecute the otherwise illegal use of the substance, right? So it is the city of Oakland saying, we recognize that psychedelics are federally illegal, but we will not, we have other things to deal with in the city, and we're not going to we're not going to enforce it, right? So that would be decriminalization. Is the city's not going to enforce, the state's not going to enforce, you're probably not going to get busted by the state police. All Schedule 1 controlled substances are federally illegal, which means that the federal government retains authority to prosecute whenever it wants, right? So, and the same with legalization. So Oregon and Colorado have, you might have heard, enacted legislation and implemented programs to make certain psychedelics to legalize it. In Oregon, there's a very, very specific state framework. You have to get for state licensed therapists who have undergone a Oregon-approved licensing process in a state licensed facility for certain substances, and usually it's dealing with natural plants like psilocybin. So Oregon and Colorado have legal frameworks for this, but it still remains federally illegal. And so what that means is you won't get busted by the state police usually for following all of the state rules, but the federal government still retains the authority to prosecute if they want to. And here, of course, the next question I always get is, well, what about cannabis, which remains and has been a Schedule 1 controlled substance federally for a very, very long time, but is legal in so many states. Well, okay, cannabis is a little bit different because there's something that is called, it's referred to as the Cole Memorandum, which was issued by the DOJ in the Obama administration, and that memorandum was a memo from the DOJ that said that the federal government was not going to extend federal resources to enforce cannabis laws where in states where the state legislature has found that cannabis is legal. Right? And so that was the whole that's the federal government coming and saying we're not going to use our resources, we have other things to take care of. The Cole memo was actually rescinded eventually under the last administration. It is not reinstated, but the attorneys generals have stated that look, basically it hasn't officially been reinstated, but because there's this really large contingent of states that have made this legal, it's really I mean, technically the federal government retains authority to enforce, but we haven't seen it happen that much, you know. So there's sort of like a modicum of protection when it comes to cannabis that does not exist at all with psychedelics. There's no Cole memorandum for psychedelics. The Cole memorandum never discussed psychedelics. So there's not even like a sort of color of the DOJ coming by and saying, hey, we're not going to enforce this. So that's a little bit about why, about just the framework of state legality and decriminalization versus legalization. Then, of course, the next question is, however, I have friends who have a mushroom chocolate business. I see this all over. If you Google, there are so many businesses where you can buy all sorts of mushroom chocolates everywhere on, Signal or Telegram or everything. What about them? Because they're doing great and they're still and they're operating in all sorts of states. They sell things all over the United States. My answer to that is, well, that's awesome. You hear about them. You don't hear about the ones that get enforced on, really, because those people disappear, their assets get seized, and they go to jail. So just because things exist on the internet and you see businesses that look really awesome and have all sorts of weird disclaimers that I have no idea who wrote that are on their websites, it doesn't mean that it's not federally illegal and that psilocybin does not remain a Schedule I controlled substance. What if I sell mushroom spores? What if I sell substrate? What if I sell anything else having to do with a little aquarium looking thing that grows your mushrooms, but I don't sell the actual fruiting bodies and I sell everything that you need? Here we get into drug paraphernalia laws, and Husch Blackwell has a really established cannabis group, and right, we've had cannabis clients who have had Customs and Border Control seize glass jars. They're unlabeled glass jars, and they're just like a glass jar that was intended to hold cannabis. And so that's happened. And so I think that's a really good example of just sort of the breadth of these laws. And enforcement is discretionary, but it doesn't mean that you will, you can always make these arguments. Of course, it's substrate. It's like, that you can grow culinary mushrooms in this, and you can grow, all sorts of other things in using mushroom substrate or the nutrients that you need, things like that. But you have to be careful. You have to be careful because it doesn't mean that it's legal. It doesn't mean that it can't be enforced upon. And you don't want to be in a situation where you are enforced upon and then you have to make these arguments. This one is my favorite of all time, and it is, what if I start a church? And Kim is smiling, my co-lead for my practice group is smiling over here because about once a week I will have a conniption because somebody has called me and asked me about their psychedelic business, and then their follow-up question is, but what if I start a church? So let's get into this. Right, we have something called the Religious Freedom Restoration Act. What is the RFRA? In 1993, the United States Congress enacted the Religious Freedom Restoration Act with an intent to protect individuals' rights to practice their religion without undue government interference. RFA emerged as a response to the Supreme Court decision in a case called Employment Division versus Smith, which restricted religious exemptions from laws that applied across the board. Now, RFRA was designed to ensure that religious practices are accommodated unless there is a compelling government interest at stake, and even then, that the least restrictive means must be used. Initially, RFRA was not associated with the use of psychedelics. However, its implications extend to various spheres, including the use of controlled substances within the framework of religious expression. And the Act provides a legal basis for certain religious groups to use otherwise illegal substances, such as peyote in Native American sacramental rituals, and more recently, ayahuasca in ceremonies. So there's a landmark case here called Gonzalez versus, it's called otherwise known as UDV Church. So this court, in this Supreme Court case, the court ruled unanimously that the UDV Church could use ayahuasca. It was a brew containing DMT as part of its religious ceremonies under RFRA, emphasizing religious freedom and acknowledging the responsible sacramental use of psychedelics. And I think a lot of people look at this case and they get really excited, and and they say, hey, what if what if I couch this, and what if there's a path going forward, if I establish a religious church. So despite this ruling and a couple other cases have come out, the applicability of RFRA to psychedelics definitely has its challenges. So critically, we have to talk about what critically RFRA protects sincere religious practice, right? And sincere religious practice involving the sacramental use of a psychedelic in that sincere religious practice. Sacramental use has been interpreted to mean use to aid, I don't know the exact words they were using, but it's basically communion with God, right? So it's use only for communing with God, communing with a higher power in your religious practice. If you have a psychedelic business that is using psychedelics or developing psychedelics for therapy to treat PTSD, to help people with their depression, to help physical ailments, that is directly your argument. That's a direct argument against its sacramental use. And that is why I think companies, especially since we're a psychedelic business forum, right? Like, why just being here and then asking that question is sort of like you have a business that you want, and then you're trying to kind of shoehorn our RFRA into this and saying, hey, can I use this as a different avenue for my business? And I believe that that would be a very hard argument to make if you are being enforced on, to say that it's actually a church, because it'll, people look at it and be like, is this really your sincere religious practice when clearly you have this other business idea? So there's really an ongoing debate about where draw the line between religious freedom and public interest, also particularly when it comes to substances that are otherwise illegal. It's an ongoing debate. I don't think that the DEA would sort of take kindly to this kind of argument. The DEA does actually have an application process for your religious church to use. I feel like only one church has actually successfully ever applied for it. I remember looking at the application a while ago, and I was like, I don't know. Like, I have no idea how they decide, who decides. I bet it's like very capricious and arbitrary, like a lot of DEA's, or in my opinion, decisions. However, it's not an easy path to take. And whenever anyone asks me about this, I really have them imagine, like, these arguments are really good arguments. There is a really compelling constitutional argument about religious freedom and the exercise of religious freedom, but there is a big chance that you would be making those arguments from jail. And do you want to make that argument from jail? Because it's an awesome thing to think about. It's great to talk about. But where are you going to be when you actually have to make this argument, and your freedom is at stake, your assets are at stake. So that's not, I don't know. It's something that I tell people to be really careful about. I've only met a handful of people who've ever asked me this question that I really thought were, yeah, you do have a church, and this is what you're trying to protect, and it's a really noble cause. But be careful if you also have a business idea. Modern implications. Let's talk about civil asset forfeiture. Civil asset forfeiture is a legal tool that gives law enforcement authorities the power to seize assets they suspect are connected to criminal activity. So it's really critical to highlight the key point here, which is that this process does not require a criminal conviction. So when that Supreme Court case I was talking about earlier, the ayahuasca church in New Mexico, really, actually, no, they didn't. Those people didn't make the argument from jail. I was really surprised. They actually didn't arrest anyone. What they did is they seized all their assets first, though, and that can sometimes be, also devastating for people. So, in the world of civil asset forfeiture, the usually we're accustomed to the presumption of innocence, right? And where it's up to the state to prove somebody's guilt. But in the instance of civil asset forfeiture, the script is often flipped, and it is commonly up to the property owner themselves to step forward and prove the innocence of their assets to get them back. It can take a long time. It's expensive. In the meantime, you don't have your assets. So let's talk scope. The breadth of assets subject to seizure under the civil asset forfeiture can be staggering. We're not just talking about a wad of cash that somebody finds during a traffic stop. Law enforcement can seize everything from your car to your family's home. All it takes is a suspicion, just a suspicion, mind you, that these assets were involved in criminal activities and, for example, the use of unauthorized use of a Schedule I controlled substance. So, it can get really dangerous there with the enforcement. I feel like I've maybe scared you guys enough and told you about, all the things that you shouldn't do and you can't do. So what can you do? What's the regulatory framework for drug development? Start with a really high level overview of this. The most important regulatory agencies for psychedelics are the FDA and the DEA. There's 21 USC 812 here is the Controlled Substances Act, which it has the 5 schedules of controlled substances. And I will talk about all that in just a little bit. Let's start with the CSA, Controlled Substances Act. It's passed in 1970. It establishes a closed system of distribution with 5 schedules of controlled substances. It regulates prescriptions and record retention of drugs, and it works in conjunction with state laws governing controlled substances. Following the passage of the CSA in 1973, the DEA was established to coordinate federal drug control activities. DEA is authorized to register the dispensers, practitioners, pharmacies. In addition, the Controlled Substances Act requires the FDA to inform the DEA of drugs that appear to have abuse potential. I guess I'm missing a slide here. So about the FDA. Where does the FDA fit in here? FDA is part of the Department of Health and Human Services, and it regulates for drug safety, efficacy, and security. And so, and the abuse potential of a drug is also considered a safety issue. So we have the FDCA, which is Federal Food, Drug, and Cosmetics Act. It's under the FDCA. The FDA regulates all articles that are intended for use for the diagnosis, cure, mitigation, treatment, or prevention of disease in man. This is why psychedelic therapy falls under the FDA's regulatory jurisdiction, because it is used to treat several types of disorders in humans. Since 1963, all new drugs have been subject to pre-market review and approval by the FDA upon filing of something called a new drug application, or NDA. The new drug application includes all of the information that such a drug is safe for use, and it must include information about abuse potential, including, if applicable, a proposal for scheduling under the Controlled Substances Act. Every drug, it again has to be assessed for drug dependence and abuse potential. And importantly, for psychedelics, the regulations on submission to a clinical trial for investigational new drug, or IND, they require submission of information for drug dependence and its abuse potential, specifically if the drug is a psychotropic substance. So the DEA is part of the DOJ, Department of Justice. It is the enforcement arm. It controls and it prosecutes those who traffic and abuse any of the controlled substances on its list. And in addition to being tasked with the enforcement of the CSA, DEA has specific rules for researchers who intend to conduct research with Schedule I substances. I'm going to go over the actual process of obtaining a DEA research license a little bit later in this presentation. It's called a DEA Form 225 application. In addition to completing this application, a Schedule I researcher has to file and receive approval for a research protocol. So let's talk about the schedules of controlled substances and under the that the DEA has established. So most people know that there's 5 schedules. Schedule I is the most highly regulated or the highest schedule. It's known, it's drugs that have a high potential for abuse. Critically, the definition of a Schedule I drug is that there is no currently accepted medical use. And when you think about certain drugs, such as cannabis, which remains on Schedule I, or such as psilocybin, and the panoply of literature, scholarly literature, clinical trials, things like that are coming out that actually show that it does have a currently accepted medical use. It's very interesting that these drugs remain on Schedule I. So some other drugs that are on Schedule I are LSD and heroin. Moving on to Schedule II, these substances are still risky. They have a high potential for abuse. They might lead to severe psychological or physical dependence. Unlike Schedule I, they do have accepted medical uses, often under strict controls. Some examples of Schedule II drugs are cocaine, methamphetamine, oxycodone, or the opioids. And so these are interesting because it's sort of the difference between a Schedule I and a Schedule II drug is really just the ability of medical professionals to be able to provide it for a recognized medical use. My firm was involved in a really interesting case with the Ninth Circuit last year, and this year we helped draft amicus briefs in a direct petition to the DEA to reschedule psilocybin from Schedule I to II in the context of its proven and accepted medical use for palliative care patients, like end-of-life patients, to deal with end-of-life anxiety and just existential distress. And it is going to be really interesting to see how that case and other similar efforts play out in the context of these drugs that many will argue do have accepted medical use that remain in Schedule I. So we have Schedule III, IV, and V that are just decrease in levels of perceived danger, physical dependence, things like that. Schedule III is ketamine. That is increasingly being used in psychedelic therapy and a lot of times off-label. Schedule IV, some examples are Xanax and Ambien. And Schedule V, you have things that are in cough syrup. So in summary, the Controlled Substances Act schedules, they may sometimes seem counterintuitive. They throw a few curveballs with substances that we might not expect. The takeaway, I think, is not to judge a drug by its reputation, but to understand its position in the legal and medical context. And it's just to remember that it's a balancing act between recognizing medical benefits and mitigating the risks of abuse. So let's talk about what happens if there's potential for abuse in the substance that you are developing. Picture this: you've developed a new pharmaceutical product. It shows promise. It has the potential to alleviate pain or treat disorders or perhaps even save lives. But along with its therapeutic benefits, there is always a looming question: does this new drug have the potential for abuse? This is where the synergy between FDA and DEA becomes paramount. And according to the protocol outlined in 21 CFR 314.104, if during the FDA's meticulous review process, a drug shows signs of possible abuse potential, FDA has to alert the DEA. So the Controlled Substances Act enforces this critical check. Why is this step indispensable? It's simple because it strikes a balance between the availability of medications to those in need and protection of public health and safety. And there's this assessment here of abuse deterrence measures, and we're not just talking about creating barriers to abuse, but we're engineering smarter and safer drugs that aim to sort of outwit the possibility of misuse straight from the drawing board. Abuse deterrent formulations target the known or expected routes of abuse, such as crushing in order to snort or dissolving in order to inject for the specific drug substance. And one interesting things that I've seen some companies develop is, for example, if it's a skin patch, making it so that you can't scrape the substance or extract the substance from the skin patch so that you can snort it, for example, for abuse. I'm going to skip over a little bit. I think I'm moving a little bit behind this presentation and talk about REMS, which is a really important acronym for you to remember in drug development. It stands for Risk Evaluation and Mitigation Strategy. And REMS is required in the submission of your new drug application to the FDA when it is necessary to ensure the benefits of a drug. When it is necessary to ensure that the benefits of the drug outweigh the risks of the drug. So imagine for a moment that you're balancing two scales. On one side, you have the potential for life-altering treatment, and on the other side, the risks associated with the very same medication, particularly with abuse potential. This delicate balance is where the REMS becomes pivotal, and it's not simply a compliance checkbox. It's a nuanced strategy that's mandated by the FDA when the drugs in question come with significant risks. These risks necessitate a rigorous evaluation of to assure that the therapeutic benefits justify their use. So it's really sort of a balancing act. Includes things like the estimated size of the population likely to use the drug, the seriousness of the disease or condition, the expected or actual duration of the treatment, known or seriousness of any known or potential adverse events, and whether the drug is a new molecular entity. Once the FDA approves a drug, it makes a scheduling recommendation to the DEA, and the DEA has 90 days then to reschedule the drug, and it passes to the states. So states vary in their approach to rescheduling. Some states sort of have what I'll refer to as, they're sort of like synchronized swimmers. They have things that are kind of like trigger laws, where if the DEA reschedules a substance that has been approved by the FDA, then that state will adopt whatever the DEA says. In other states, and they have an agency, a state agency that steps in the spotlight and does their own sort of analysis and then reschedules based on that. Lastly, there's some states have a legislative approach, and they need to involve the legislature in order to make that decision.
Oh, that's okay.
And your TTI, those are usually smaller things.
Okay. Right.
Sometimes when I have phone calls,
Okay.
People like commodity.
Anyway,
I don't know, the potentiometer, you can see what type of potentiometer and which line that
I'm trying to figure out what they're saying.
Very good.
Hi,
Yeah,
can you hear me?
wonderful. Can I have this? Thank you so much.
No.
Nice to meet you.
Okay, they can't hear me.
My
We can
hands
all
are
hear.
full. Oh, there we go.
This slide here shows the breakdown of approaches that states take to federal scheduling of substance. We're over. Okay, never mind. Wanted to talk to you about MDMA and Lykos Therapeutics submission to the FDA, but and I also have a lot more to talk about. Would love to talk to you guys during the break or answer any questions. Thank you.
Hello. Awesome. Thank you so much, Karen. Can we get one more? Hello. Can we get one more round of applause for Karen? So one of the key insights that I took away was really federal state approaches. Really glad Karen brought up Oregon on there. Is that this week actually there was a historic event with the church, and yeah, and for the sincere religious practice, and they had been using ayahuasca as their sacrament, and so the DEA is now going to allow them to use ayahuasca as a part of their religious practice. And it's a U.S.-based church. However, what their sacrament and the religious use is based around the practices of great. And kicked off this meeting, we are here today because of these ancient practices. That is how this industry has even emerged. And so it's really important. RIFRA gives us a way of honoring those traditions and keeping those and protecting those traditions. And so when there is sincere religious practice, that can be a really important way. The other important distinction is, of course, in the US, the IRS treats churches as a type of nonprofit, right? And so if you're trying to make a business case while simultaneously saying it's a nonprofit church, that's that disconnect that Karen was talking about, right? So Serena and I, also counsel clients on these kinds of questions. And it's really important, as Karen says, to understand those gray areas, because this is an industry that is coming up from underground to now hopefully above the ground.